one arrow, one pet, and one cruel death. On July 29, 2015, the defendant, a veterinarian, annoyed, frustrated, and fed up, decided to take matters into her own hands. So she grabbed her bow and arrow, aimed, and shot an animal. An animal who we know was Chester, a ferret, a therapy and assistance animal.
Counsel, I'd like to ask you a question about the therapy and assistance animal part of this. What evidence is there from which we can conclude beyond a reasonable doubt that Chester has actually been trained? And it's the training part that I'd like you to focus on. What is the evidence in the record that he has been trained to be a therapy animal?
Your Honor, there's evidence in the record that Chester was taken to Pause for Cause, a program that trains animals like cats, dogs, and ferrets to be therapy animals who can provide assistance for emotional kids like Stevie. And because he was taken to Pause for Cause, Chester was trained to provide those services for Stevie.
Wasn't the testimony from Ms. Meadows that the Pause for a Cause was more like a lecture or a seminar about how animals can be used for therapy and assistance purposes? And on cross-examination, didn't she testify that the animal hadn't actually received any specific testing or any specific guidance or any specific training, really, to actually be a therapy animal?
No, Your Honor. The program itself, Pause for Cause, is a recognized program that trains animals. It's our position that it's a reasonable inference that Chester was indeed trained to provide the services needed to help Stevie cope with his anxiety.
What does the statute require in terms of training?
Under the statute, the statute requires that an animal be trained for and be actively used for assistance or therapy purposes. Here, Chester received the training from Pause for Cause and was actively used by Stevie for assistance and therapy purposes.
Isn't it true, Counselor, that on the night in question, Chester was not actually with Stevie? So how can you purport that Stevie was being actively used, that Chester was being actively used as a therapy animal by Stevie?
Well, Your Honor, just because Chester wasn't with Stevie in the night in question doesn't mean that Chester didn't assist Stevie with his anxiety. In fact, we have other service animals like dogs who assist people who are blind, and these blind individuals do not receive the assistance from these dogs all the time. There are some times where they're not being used, and Chester was being used for the same purpose. So Chester was an assistance or therapy animal who was actively used for that purpose. Today, we learned about Stevie and Chester. We learned that Stevie suffers from anxiety and that it was for this reason that Miss Sally Meadows, Stevie's mom, got Chester for him 3 years ago. And during those 3 years, not only did Chester assist Stevie with his anxiety, but he was a best friend. They would go out on walks together. They would play in the backyard. Chester would even perch on Stevie's shoulder. And whenever Stevie would get ready for bed, Chester was right there by his side. Chester was free to roam as he pleased. And whenever he roamed, he always came back. Always. Except that on July 29th, 2015, Chester never came back. Because on that night, the defendant killed Chester through the unlawful use of a weapon.
Wasn't there testimony that Miss Meadows and Stevie let Chester out and that he would stay out overnight on occasion?
Yes, Your Honor. There was testimony in the record to show that there was some nights when Chester didn't come back, but Chester always came back, eventually.
And wasn't there evidence also that he would not be able to fend for himself should he come upon a coyote or some other animal that might, he would serve as prey for?
Yes, Your Honor. There was evidence in the record to indicate that, but that's not what happened in our case. In our case, the defendant killed Chester through the unlawful use of a weapon.
So how do we know that it was Chester who was killed, or that any animal was actually killed for that matter?
Although Chester's body wasn't recovered, it was Officer Bert Boxer, an animal control officer with 4 years' experience, who, after conducting a thorough investigation, found the arrow that was used to kill Chester. Not only was this arrow found in the defendant's trash can, but it contained Chester's DNA. So this DNA is circumstantial evidence that Chester was indeed killed in the night in question.
Does the state need to prove that Chester was actually killed in order for the defendant to be guilty of animal cruelty?
Not under the statute, Your Honor. Under the statute, to prove that the defendant is guilty of animal cruelty, as I said, we had to prove that the defendant either intentionally, knowingly, recklessly injured or intended to kill Chester. So the killing itself is not a necessary condition for us to meet the burden. The fact alone that Chester was injured is sufficient to find the defendant guilty of the animal cruelty charge. With respect to the unlawful use of a weapon, a person commits the crime of unlawful use of a weapon if that person attempts to use unlawfully against another any dangerous or deadly weapon, or interferes with an or discharges a firearm, blowgun, bow and arrow, crossbow, or explosive device within city limits or residential areas without having the legal authority for such discharge. There is no question that the defendant discharged her bow and arrow. She admitted it on the stand, and she admitted it to the entire world on social media when she posted this on Twitter.
I want to ask you a question about this Twitter post here. The hashtag feral pests, is that not indicative of the defendant's mental state at the time that she believed that she had either shot at and or killed a feral pest, which wouldn't be considered an animal under the statute? And if that's the case, if her mental state was that she believed she was shooting at a feral cat or a feral pest, isn't she not guilty of animal cruelty and interference with an assistance animal?
Your Honor, even if that's true, that would go to the intentional element of the crime. She still either knowingly or at the very least recklessly killed Chester. She recklessly killed Chester because she consciously regarded the substantial and unjustifiable risk that by shooting her bow and arrow, she was likely to shoot one of Ms. Meadows' pets. Here, that's exactly what happened. She consciously regarded that substantial and justifiable risk. She shot her bow and arrow. She knew that there was a chance that one of Ms. Meadows' pets, including Chester, would run into her backyard. She consciously regarded the substantial and unjustifiable risk, and she would be guilty beyond a reasonable doubt on the mere state of mind that she was reckless.
Counsel, I got a question for you on the culpable mental state. What is the operative culpable mental state with respect to the state's theory of the case as it applies to counts 1 and count 2?
With respect to count 1, which is the animal cruelty charge, the defendant, it is our position that the defendant intentionally killed Chester. But our position is also that if this court is not convinced that the defendant intentionally killed Chester, there's evidence in the record to indicate that the defendant's actions were committed knowingly, and if not knowingly, at the very least, at the minimum, her actions were committed recklessly.
So you're inviting us to find her guilty on count 1 on a reckless theory. True?
Yes, Your Honor.
If we do that, do you not necessarily concede defeat on count 2?
No, Your Honor, because we still have evidence in the record to show that the defendant intentionally and knowingly committed the acts so that she's guilty under counts 1 and 2.
So your theory is there's a different applicable culpable mental state factually as applied to count 1 and the conduct that led to the death of the animal, and count 2 that led to the death of the animal, but in this case, because it's a therapy animal, it's a different outcome, right?
Yes, Your Honor. Yes. The question with respect to the unlawful use of a weapon, the defendant admitted that she discharged her weapon. There's no question about it. So the question turns on whether the defendant had any legal authority for such discharge. The defendant did not. The defendant did nothing but provide 2 ineffective reasons to establish legal authority. One, she claimed that she was trying to protect a wild bird.
Well, I mean, it's not the defendant's burden to establish that she had legal authority, right? It's the state's burden to prove beyond a reasonable doubt that she didn't. So what evidence can we point to that she did not have legal justification to shoot her bow and arrow? I mean, how is this any different than the classes that she takes where people are discharging bows and arrows routinely inside city limits? What are the parameters of that?
Well, Your Honor, it's true that the defense does not have any burden to show that we, as a state, we carry this burden. And there were 2 possible ways in which the defendant could have established legal authority. One of those 2 ways was that she was either trying to protect a wild bird or that she was trying to protect her dog. And those are two of the reasons that could have established the necessary legal authority to find her not guilty under the statute. Here, the defendant's reasons that she was trying to protect a wild bird and that she was trying to protect a dog do not establish the necessary legal authority. Her first reason, that she was trying to protect a wild bird, does not satisfy the legal authority element here because she was protecting, wild animals are simply not protected in this jurisdiction. An animal protected in this jurisdiction means any domesticated living creature, which does not include a wild animal, livestock, vermin, or pets.
Is it the state's position that the defendant has to provide an explanation for justification for discharging a bow and arrow, or they're guilty of unlawful use of a weapon?
No, Your Honor. It is not our position that the defendant has to justify, that the defendant has to prove that they have legal authority. It is our position that the defendant is without any legal authority, that the two possible reasons that could have established legal authority simply do not establish the legal authority. The fact that she was trying to protect a wild bird and the fact that she was trying to protect her dog could have been reasons to establish the necessary legal authority, but they do not. And because there is no legal authority, the defendant is guilty for the discharge of her bow and arrow. The defendant is also guilty of animal cruelty. As we discussed previously, a person commits the crime of cruelty to animals if that person intentionally, knowingly, or recklessly kills or causes serious physical injury to an animal in a cruel manner without the animal's owner's consent.
Since there was no body found, how do we know that Chester, or any animal for that matter, was killed or seriously injured?
Your Honor, Officer Boxer, the animal control officer at the scene, testified that he found the arrow that was used to kill Chester. And not only was his arrow found in the defendant's trash can, but it contained Chester's DNA. Dr. Mildred Cheever, the tenured professor at the University of Clementine, a veterinarian with 11 years experience and with 3 years experience in veterinarian forensics, testified that she conducted DNA testing on that arrow, and she concluded with a reasonable degree of scientific certainty that the DNA on that arrow matched the sample for Chester.
What about the blood? How does the state explain that there was no blood on the arrow?
Your Honor, although there wasn't any blood, the defendant, as Your Honors recall, the defendant removed her Twitter post. She was just as likely to clean the arrow and throw it away. In fact, Dr. Cheever testified that if the arrow did come from the trash, it was surprisingly clean.
If she had cleaned the arrow, would that not have removed saliva as well?
It's a possibility, but in this case, it did not. She tried to clean the arrow, but fortunately there was enough DNA on the arrow for us to sustain our burden to find, through circumstantial evidence, that the defendant killed Chester.
What about the possibility that the arrow could have been cross-contaminated? On cross-examination, she did admit that cross-contamination was a real possibility. I mean, what is the state's response to that?
Well, Your Honor, our theory of the case is that the defendant shot Chester in the night in question, and that she cleaned the arrow and threw it away. There was a 1 hour gap between the time that she posted to Twitter, which was 9:07 p.m., and when she called animal control at 10:50 p.m. Officer Boxer testified to this. And it was that 1 hour gap that is unaccounted for, in which the defendant could have had the time to clean the arrow and throw it away.
Does the possibility of cross-contamination, does that not create a reasonable doubt about whether that arrow was an arrow that killed or injured an animal, or Chester?
Well, Dr. Cheever testified that the chances of the trace DNA matching an animal other than Chester was 1 in 10,000. And we have an arrow that contains Chester's DNA. And the only reasonable conclusion is that the defendant took that arrow, cleaned it, and threw it away.
Counsel, are you not troubled by the differential between the population statistics that drive human DNA studies and the fact that when you get a rule out or a match in common parlance on DNA, we're looking at statistics of 1 in 8 billion, 1 in 6 billion, that range, on a human case, but in an animal case such as this, the number we're getting back is only 1 in 10,000. Doesn't that suggest that the system is still inherently flawed as applied to animals?
No, Your Honor. 1 in 10,000 is still significant evidence that the DNA is the sample for Chester. Although there's a difference between humans and animals, there are significantly less feral animals, or I'm sorry, ferrets in the neighborhood. So the 1 in 10,000 is a significant evidence that the DNA did in fact match the sample for Chester. Not only did the defendant have the motive to kill Chester, but the degree of skill. The defendant had been taking archery classes prior to killing Chester. She was an excellent marksman. Not only she was so good that she skipped the intermediate course and went straight to the advanced class. On July 14, 2015, 2 weeks prior to the death of Chester, the defendant complained about an animal hoarder, and this animal hoarder was Miss Sally Meadows. And it was Officer Bert Boxer who responded to this call. Officer Boxer testified that when he arrived at the defendant's home, the defendant complained that there were too many cats living on Ms. Meadows' property. And Officer Boxer told the defendant that there was nothing he could do. He explained to her that although there's a county ordinance that prohibits an individual from owning more than 10 animals, there was nothing he could do.
I think we might be getting short on time. Could you talk to me a little bit about how, if Chester was actually killed or injured, why that was done in a cruel manner?
Yes, Your Honor. Under the statute, cruel manner means a manner that is likely to cause unjustified pain or suffering. Here, on July 29, 2015, the defendant grabbed her bow and arrow, aimed and shot it at Chester. We heard testimony from Miss Sally Meadows that she heard a screech and that it sounded like Chester, and that she had heard this screech before, except this one time in the night in question, it was 100 times worse. And not only that, but the defendant's own witness, Dr. Glinda Fritz, the veterinarian at Lakeview Vet Clinic, admitted on cross-examination that a bow and arrow is not a legitimate method of humane euthanasia. There is no doubt that the defendant's actions were cruel. The defendant is guilty of animal cruelty.
But do we actually know that Chester, if it was indeed Chester that was hit by the arrow, did Chester actually suffer pain or suffering? What facts do we have on the record to support that?
Well, we have two things, Your Honor. First, we have the arrow that contained Chester's DNA, which is circumstantial evidence that points that the defendant shot that arrow at Chester. And we also have the testimony from Dr. Glinda Fritz, the veterinarian, who testified that a bow and arrow is not a legitimate method of humane euthanasia of a healthy non-rabid animal. Chester was a healthy non-rabid animal. A bow and arrow, Dr. Glinda Fritz testified that a bow and arrow does not minimize pain and that it is a cruel manner.
Do you as the state actually have to prove that Chester did suffer pain and suffering under the cruel manner definition?
We just have to show that the defendant's actions were committed in a cruel manner under the statute. The defendant is guilty of animal cruelty. The defendant is also guilty of the remaining charge. The defendant is guilty of interference with an assistance or therapy animal. A person commits the crime of interference with an assistance or therapy animal if that person intentionally or knowingly injures an assistance or therapy animal that the person knows or reasonably should know.
Which prong of the interference with an assistance of a therapy animal is the state proceeding on? Which one of these theories?
The first one, Your Honor. We're proceeding on the first one, that the defendant knew or reasonably should have known that Chester was an assistance or therapy animal. We've already discussed that the defendant's actions were intentional and knowingly. So the question in this charge really turns on whether Chester was an assistance or therapy animal and whether the defendant knew or reasonably should have known that Chester was an assistance or therapy animal.
Can you address the second part of that, whether the defendant actually knew or should have known?
Yes, Your Honor. The defendant knew or reasonably should have known. Ms. Meadows testified that Chester and Stevie, while walking down the block, ran into the defendant a few times. The defendant admitted that it was weird running into them, and you don't forget something like that. And not only that, but people in the community knew who Chester was to Stevie. People in the community knew that Stevie had special needs, and people in the community knew that Chester was an assistance or therapy animal. The defendant was a member of that community. The defendant knew or reasonably should have known that Chester was an assistance or therapy animal. The defendant is guilty of interference with an assistance or therapy animal. Chester wasn't just an assistance or therapy animal. He was a best friend, and the defendant took this away from Stevie. The defendant is guilty of animal cruelty, guilty of interference with an assistance animal, and guilty of unlawful use of a weapon. We ask that this court find the defendant guilty on all counts.
All right.
Thank you.
Thanks very much.
Unjustified, inexcusable, and inhumane. Caitlin Landley's actions on July 29th, 2015 were unjustified, inexcusable, and inhumane. Your Honors, when I came to speak to you during opening statements, I told you that the state has brought 3 charges against the defendant: the unlawful use of a weapon, interference with an assistance or therapy animal, and animal cruelty.
Counsel, doesn't the fact that the state was unable to produce a body or any blood create a reasonable doubt that any animal was injured or killed in this case?
No, Your Honor, it doesn't. And the defendant herself admitted in her testimony that there was a carcass in her backyard, and she hypothesized that that carcass was probably taken by a coyote. So it's problematic that there is no body, but it doesn't create a reasonable doubt because the defendant admitted that she killed an animal. She told you that she took a bow and arrow, she shot the animal, that it lay dead in her backyard, and that she called animal control to remove that carcass from her yard. On July 29th, 2013...
Let me just follow that up with one more question. Does it matter whether an animal was killed?
Yes, Your Honor. It matters for the 3rd charge of animal cruelty. You have to prove that an animal was killed or was seriously injured. So in this case, we have Caitlin Landley's tweet that establishes that she killed the animal. We also have her testimony that she gave you on the stand that she killed an animal.
But if it was a feral animal, a feral pest, does it qualify under the statute?
It would still qualify under animal cruelty. That would present a problem for the interference with an assistance or therapy animal. The 3rd prong of that charge requires you to prove that the animal was in fact an assistance or therapy animal. However, with all the evidence that you've heard throughout the course of this trial, that Mrs. Meadows heard her son Stevie's service animal Chester shriek in pain at the exact same time that the defendant admits to shooting an animal, we know that that animal was Chester.
I just want to make sure I understand the state's position here. Is it the state's position that a feral animal, one of the feral cats, there was evidence in the record that there were many feral cats on the property, is it the state's position that these feral animals constitute animals as defined in the statute?
Yes, Your Honor. Under the animal cruelty charge, I believe that the feral animals would still qualify as an animal. Moreover, there is no evidence that that animal was a feral cat. The defendant has presented absolutely no evidence to show whether that animal that she admits to killing was a feral animal, whether it was a cat, whether it was a ferret, whether it was someone else's pet. The defendant claims that she has no idea what kind of animal it was.
But the state has the burden of proof in this case, correct? The defendant does not need to prove or to disprove beyond a reasonable doubt your case that this was not a feral animal.
That is true, Your Honor, and we do bear the burden, but we have met that burden, admittedly through circumstantial evidence, but circumstantial evidence is weighed the same as direct evidence, that Mrs. Meadows heard that animal, her son's therapy animal, shriek at the same time that the defendant admits to killing that animal.
Didn't she say it was the sound of a cat, and there were many cats, 15 to 20 cats that were feral, and 8 of Miss Meadows' own cats? So couldn't it have been one of the cats? She said it sounded just like a cat.
No, Your Honor. She started by saying it sounded like a cat, but then she specified that she had previously heard Chester specifically shriek when her son Stevie accidentally stepped on his tail. And she said that's how she knew that it was Chester shrieking, because she had heard him before and it sounded the same except 100 times worse. So she knew that it was Chester that was shot. Moreover, Chester would frequently go out with Mrs. Meadows' cats. She would let them all out every night. She had 6 cats, I believe, at that time that she would let out, and Chester would go outside with them to play. they would always come back every night before bed, and Chester would sleep in bed with her son Stevie. Chester didn't come back that night, and that's very out of character for that animal. So the only reasonable explanation here is that the animal that Caitlin Lanley admits to shooting was, in fact, Chester.
Wasn't there evidence, though, that Chester had left the house and spent overnight previously outside?
That is true. That Mrs. Meadows did say that on occasion, when Stevie was gone, as he was that weekend, that Chester would leave for the night, but that he would always return. So him not coming back that night maybe wouldn't be so out of character, but not coming back at all certainly was out of character.
But wasn't there evidence that there were coyotes in the area that would have, was possible that they could have picked him up?
Yes, Your Honor. However, what's more likely is that they picked up his dead body after Caitlin Lanley shot him. And that's why Caitlin Lanley is on trial today, because she admits to shooting an animal. That animal was Chester. Caitlin Lanley told you that she was fed up with Mrs. Meadows' animals. She called animal control on July 14th, 2015, just 2 weeks before she shot Chester. And she complained to Officer Buddy Boxer that Mrs. Meadows had too many animals, too many of her own cats, and Chester, and then the feral cats that Mrs. Meadows fed. Officer Boxer explained to Caitlin Lanley that there was nothing he could do, that the local ordinance allows up to 8 cats or dogs for a person to own, and that feeding feral animals is not illegal. So there was nothing that animal control could do to prevent Mrs. Meadows from feeding feral cats. At that point, Caitlin Lanley said she had to do something about it. And what she did in response to that was vigilante justice. And this court cannot allow people to engage in vigilante justice. When they're not happy with the actions of their neighbor, they're not allowed to shoot their neighbor's pet, their neighbor's therapy animal.
If we accept the defendant's explanation that she was attempting to safeguard the birds in her backyard by discharging this area, does that create a legal justification? And I'm specifically asking this question in reference to the unlawful use of a weapon
Yes.
statute. It says that you can't discharge a bow and arrow unless you have legal justification.
Sure.
If we believe that Miss Lanley was doing this in an attempt to protect these birds, and the state has argued that she was fed up with these birds being killed and being threatened by feral animals or other animals, is she not guilty of unlawful use of a weapon? Is that a legal justification to try to protect other animals?
No, Your Honor, that's not a justification to avoid the unlawful use of a weapons charge, because the birds that she was attracting into her yard were wild birds. So when Chester came into her yard, if he did as she claims and was killing these wild birds, they were not Caitlin Lanley's pets. So there is a distinction there. If this were factually different, and it was in fact Caitlin Lanley's pet, or if there were any evidence that the animal that she shot that night had rabies, as the defendant's expert testified to, Dr. Fritz, that there was a rabies problem in Solar County in the summer of 2015, then that would make a compelling case that Caitlin Lanley had a legal justification for shooting that animal. But the defendant never claimed that the animal that she shot had rabies. And there was no proof that in Lakeview at the veterinary clinic that there was ever an animal brought in that had suffered a rabies bite. So there is no evidence that the animal that Caitlin Lanley shot had rabies. And she wasn't attempting to protect herself from an animal. She wasn't attempting to protect her pet. This was a wild bird. So you're not allowed to kill a person's pet to protect a wild animal.
Would she be not guilty if the animal had rabies?
I think of the unlawful use of a weapon charge, yes, she would probably be not guilty if she were able to establish that that animal had rabies. As Dr. Fritz testified, using a bow and arrow...
Wait a minute. The defendant needs to establish that the animal doesn't have rabies? Isn't it the state's job to prove to us, that beyond a reasonable doubt that the animal didn't have rabies, if having rabies would provide a legal justification.
Ordinarily, yes, it is the state's burden, but once the defendant argues justification, the burden shifts, and she has to prove that her action was justified. The same way that self-defense operates, if I shoot a person, normally the state has to prove their case beyond a reasonable doubt. But if I admit to shooting the person and say that I shot them in self-defense,
So
the burden shifts to me.
the state's position is that the statute incorporates a justification defense.
Yes, Your
Interesting.
Honor. And that's the third element there, that the defendant's actions were not justified. Again, if she were acting with legal authority, if she were a safety officer, a policeman, a firefighter, she would be under a different standard. But she is a civilian, and we hold our civilians to act reasonably and act in accordance with the laws. Moreover, we have Chester Meadows' certificate, which proves that he was a service or therapy animal.
Can you talk to me a little bit about this certificate? What sort of training, evaluation did Chester undergo as part of receiving this certificate?
Yes, Your Honor. Mrs. Meadows and Stevie took Chester to a training at the Lakeview Mall, where Chester was viewed by the trainers here and was given the certificate of completion.
Do we have any testimony on the record, though, that Chester was actually trained to do anything specifically, that he was actually evaluated by any of those handlers before receiving the certificate?
None of that evidence is in the record, Your Honor. However, there is no specific requirement in the statute of what an animal must do in order to be an assistance or therapy animal.
How does the statute define therapy animal?
Actually, if I can just get to that slide. Sorry. An assistance or therapy animal is an animal that has been trained for and is actively used for assistance or therapy purposes.
So training is required then as part of the statute?
Yes, Your Honor. However, it's arguable, again, what the word training means. They took Chester to this, it's called Pause for a Cause training, where they learned about assistance or therapy animals, and they talked with the trainers there. It's unclear, based on the statute, that there are a certain number of hours required for training, or that any specific procedures are required to prove that the animal is an assistance or therapy animal. What's most important here is that Stevie Meadows had special needs. He suffered from extreme anxiety. And this animal underwent a training. Whether that training was extremely extensive or not is certainly up for question. But he did undergo a training, and he did help Stevie Meadows cope with his anxiety. Evidence in the record shows the testimony by Mrs. Meadows that Stevie's anxiety was much worse before 2011 when they obtained Chester, and it is much worse now after Chester has been taken.
So are you alleging that we should base the classification of Chester as a therapy animal solely on the facts that this animal helped Stevie with his condition? Is that how the state is purporting to define therapy animal?
No, Your Honor. I think it is a two-pronged test, as the statute lays out, that it has to be an animal that is trained for therapy purposes and an animal that is actively used for
Can you talk to me about that active use?
Sure. Stevie used Chester on a daily basis. There is evidence in the record that Stevie could go short periods of time without seeing Chester, that he would spend weekends at his father's house. His parents are divorced. That he would spend weekends at his father's house, and his stepmother was allergic to ferrets. So he wasn't allowed to bring Chester there.
What about the school?
The school did not allow Stevie to bring Chester there either. However, Mrs. Meadows is a special education teacher at Lakeview Elementary, so he was able to cope a little bit better since her presence, she was there. She was at the school. But obviously, Stevie would have benefited if Chester had been there as well. Unfortunately, we don't have those kinds of laws in place for people who suffer from mental impairments. We do have those kind of laws in place for people who have physical impairments. You're allowed to have a seeing eye dog if you're blind. But if you have extreme anxiety, there's nothing to protect you to allow you to take your therapy animal to school or on a plane. So all we have is this law that protects assistance or therapy animals from interference.
Can you talk to us about whether the defendant knew or reasonably should have known that Chester was a therapy animal?
Sure, Your Honor. The defendant either knew or reasonably should have known that Chester was an assistance or therapy animal. Chester, he didn't wear a harness that said that he was an assistance or therapy animal, but he did have a collar with a bell on it, so it was clear that he belonged to someone. And Mrs. Meadows testified that it is well known in her community that Stevie has special needs and that Chester helped her with those special needs.
And that, how does that help us with defendant's personal knowledge?
Sure, Your Honor, because defendant Caitlin Landley was Mrs. Meadows' neighbor. She was a member of that community. So even if she didn't have specific knowledge of that, she should have known. She had, in fact, seen Stevie and Chester, that Stevie would walk Chester on a leash down the street. She commented during her testimony that she remembered it specifically because she thought it was super weird.
But did Chester wear any kind of identifying markers showing that he was an assistance animal specifically?
No.
Did he only wear a harness?
No, he did not wear any specific markers, Your Honor. He wore a harness when he was being walked, and he always wore a collar with a bell on it. So there was no bright red flashing sign that said this is an assistance or therapy animal. But the defendant testifies that she didn't know that Stevie had special needs, and she didn't know that the animal was an assistance or therapy animal. But she was a member of that community, and it was widely known in that community that Stevie had special needs, that Chester assisted him with those needs. So if the defendant chose not to know about that, the state can't compensate for that. If the defendant chose to remain ignorant, chose not to know anything about her neighbors, that doesn't prove that she is innocent on these charges, because a reasonable person in her situation would have known. Moreover, the defendant is a veterinarian. She's a trained archer, which goes to establish that she knew what she was doing, both that Chester was in her backyard and that she intentionally shot him. A veterinarian, more than any layperson, should be able to look out their back window and identify the animal in their backyard.
But wasn't it getting dark out? And she said she just saw a dark object moving in the backyard.
Yes, Your Honor, it was nearing darkness. However, Mrs. Meadows testified that she could still see to the end of her yard at the time, and the defendant, Caitlin Landley, could see well enough to aim and shoot at an animal. So one could infer that she could, in fact, see what kind of animal she was shooting at. Now, for the animal cruelty charge, we only have to establish recklessness. And by picking up that arrow and shooting the animal, her behavior was certainly reckless. But under the interference with an assistance or therapy animal charge, we do have to prove intent or knowledge. It is clear that a veterinarian, that a trained archer, should at least know that by picking up a bow and arrow and shooting it towards a dark object moving on the ground, that she might injure or kill that animal. If not, that she intended to kill that animal. But again, we don't have to establish intent, just knowingly on the interference.
You do have to establish that the animal was killed or physically injured in a cruel manner. Can you talk to me about how you have proven that this animal, if killed or injured, was done so in a cruel manner?
Yes, Your Honor. Actually, the defendant's own expert witness testified to that. Dr. Fritz got on the stand. She's a veterinarian at Lakeview Veterinary Clinic. She testified that killing an animal that is non-rabid with a bow and arrow is an inhumane and cruel way to kill an animal. Now, again, there has been no testimony that the animal that Caitlin Landley shot was rabid, and she admits to killing that animal with a bow and arrow. Therefore, the method that she chose to kill that animal was inhumane.
Anything else?
No, Your Honor. I would just ask that you hold Caitlin Landley guilty for her actions on July 29th, 2015, that she either intended to kill Chester when she picked up a bow and arrow and shot him, or she at least knew that that was a probable or likely result of her actions. Thank you.
My name is Nicholas Selger, and I represent the prosecution in the state versus Caitlin Landley. Vet of the Year. That's what the defendant typed and posted on her Twitter account moments after she shot and killed her 10-year-old neighbor's service animal.
And right before that, it says hashtag feral pets. If it was a feral pest, would it qualify under the statute as either animal cruelty or an interference with an assistance animal?
Well, under the animal cruelty charge, it does not matter whether it's a feral pest or not. It's unlawfully killing an animal in a cruel manner without the owner's consent. So if it was a feral pest, there would be no owner. So Your Honor is right in saying that if it was a feral pest, it would not be animal cruelty. But the animal in this case was not a feral pest. The animal in this case was Stevie Meadows' trained anxiety animal.
What if she believed that she was shooting her bow at a feral cat? What if we accept the defendant's testimony that what she thought she was doing was trying to scare away a feral animal from hurting a bird? If we accept that, isn't she not guilty of animal cruelty?
Well, Your Honor, the defendant in this case has advanced bow skills. So even if the defendant comes before you and says, I was just trying to scare the animal, the defendant is very good with a bow. And when you shoot a bow and arrow at an animal, no matter what you're trying to do, it carries with it a substantial risk. You're going to hit that animal, and you're going to kill that animal. Regardless of whether the defendant thought this was a feral pest or whether this was Chester, she still recklessly shot her bow and arrow at Chester that night. So, Chester is Stevie Meadows' trained therapy animal. And you heard about how much better Stevie did with Chester by his side. That was until the night of July 29th, 2015, when the defendant's thoughtless actions flipped Stevie's world upside down. That was the night the defendant, armed with a bow and arrow and the bow skills to use it, went to her back porch, drew an arrow in her bow, and fired that fatal shot. And when the defendant shot Chester, she didn't just take away Stevie's service animal, but she took away his best friend.
Does a feral cat constitute an animal under the statute?
Under the animal cruelty statute, Your Honor?
I mean, the definition of animal is the same for animal cruelty and interference with an assistance animal, right?
No, Your Honor. For the animal cruelty charge, it's a domesticated animal, and then under the interference with a therapy animal charge, it must be a therapy animal.
Okay, so tell me about the animal cruelty charge.
The animal cruelty charge is it's a reckless killing of any domesticated animal in a cruel manner without the owner's consent.
Does a feral cat?
A feral cat would
Feral
not.
cat count?
No, Your Honor. A feral cat would not be a domesticated animal under the statute.
If she thought she was shooting at a feral cat, is she guilty?
If the defendant thought she was shooting at a feral cat, then she may not be guilty. But of the animal cruelty charge, it doesn't matter whether you had intent to shoot at an animal that you thought was something or not.
Well, is it the defendant's subjective belief?
It's an objective belief, Your Honor. It's a reckless killing of an animal in a cruel manner without the owner's consent. So whether the defendant knew that was Chester or whether they thought it was a feral cat, the defendant was still acting recklessly when she shot a bow and arrow at an animal that night, regardless of whether it was a feral cat or Chester, because the defendant was willing to, without any evidence that a feral cat had been on her property and without any evidence that a feral cat had attacked a bird on her property, take a shot that night. She didn't care if it was Chester or it was a feral cat. She was willing to take that shot no matter what to defend her birds and to defend her dog Milo.
Okay, I got a question for you, Counsel.
Yes, Your Honor.
You're saying for count one, for purposes of animal cruelty, that the defendant's culpable mental state was reckless conduct. She recklessly took that shot, killed whatever she killed, and we're done with it. Do you not then paint yourself into a corner as to count two? Do you lose count two because you've conceded that she acted recklessly, therefore she could not have acted with the higher culpable mental state as to count two?
No, Your Honor, because the second count says that the defendant must act knowingly, and that's being aware of a particular conduct. Nonetheless, the defendant was aware of the particular conduct that she was engaged in the night of July 29, 2015, which was shooting a bow and arrow at an animal. The defendant
isn't the important part knowledge about the nature of the animal, though? I mean, of course she knew she was pulling back the string and firing the bow. Isn't the important part of the knowledge component with respect to the result that's going to occur because of that, which doesn't that depend on what it is, what you think it is that you're aiming at?
Well, Your Honor, it says that it must be consciously aware of a particular conduct. And in this case, the particular conduct the defendant was engaged in was shooting a bow and arrow at an animal. I do not believe it matters whether that she thought she was shooting at Chester, but it's the fact that she was engaging in a particular conduct that night, shooting a bow and arrow at an animal off her back porch.
Can a defendant have two different culpable mental states for one particular action?
Your Honor, on these two different charges, the defendant could have acted recklessly by discharging her bow and arrow, disregarding a substantial and unjustifiable risk that she would kill the animal she was shooting at. But at the same time, she could be aware of the particular conduct she was engaged in, which was shooting a bow and arrow at an animal. So the defendant could have two different mental states in this case, one being reckless for count one being knowing for count two, Your Honor. Now I want to move to count three first, the unlawful use of a weapon. Now, for us to prove to you the defendant unlawfully used a weapon, we have to prove to you the defendant discharged a bow and arrow within a residential area without legal authority to do so. Now, the defendant told you in her testimony that on the night of July 29th, 2015, she grabbed her bow and arrow from her kitchen, ran to her back porch, and shot an arrow. She did not have legal authority to discharge her bow and arrow, and she did not get legal authority from taking classes at a junior college. Therefore, there can be no reasonable doubt the defendant is guilty of unlawful use of a weapon because the defendant told you she did so herself.
What would constitute legal authority?
Your Honor, there is no definition of legal authority, but I can't think of a scenario where someone would be given legal authority to have a bow and arrow, to be discharging a bow and arrow in their backyard. There's no definition of legal authority under the law. But, for example, someone might...
target practice. I would give a bow and arrow, go backyard, bale of hay, and I start blasting away at my bale of hay. Am I violating the statute?
Well, unless you have legal authority, someone has given you legal authority, such as, let's say, someone who has a concealed weapons permit. Not everybody can have a gun on them and keep it with them. But you get legal authority to carry a weapon when you apply for a concealed carry permit. And if you have to discharge that weapon, then you'll at least have the permit with you, and you're not carrying an unlawful weapon when you discharge a weapon at somebody.
What if there was a coyote in the backyard that was attacking her beloved dog Milo? Would that constitute legal authority to discharge the bow and arrow?
No, Your Honor. The defendant still did not have legal authority. No matter what the animal was, the defendant would have to have some sort of legal authority given to her from maybe the government power or somebody who can give her the legal authority to discharge this bow. Regardless of the animal it was, the defendant in this case did not have legal authority to discharge her bow and arrow. It's not in the record at all, Your Honors. Now that we know the defendant unlawfully used a weapon, I want to move to the animal cruelty count. Now, in order for us to prove to you the defendant unlawfully used a weapon, we have to prove to you the defendant recklessly killed a domesticated animal in a cruel manner without the owner's consent. Now, we know Chester was a domesticated animal. No dispute there. And we know that Sally Meadows did not give the defendant consent to kill Chester in this case.
Do you have to prove that she actually killed the animal? Is that what the statute says?
It's a reckless killing, Your Honor. It's reckless injure or killing. But in this case, I wanted to put killing up there because that's our theory that the defendant did kill Chester.
How are you going to do that without a body?
Well, Your Honor, Chester is gone, and there is no way to prove that the body is there. But our theory of the case is that he was recklessly killed. And we also have the arrow that we found in the trash can. So the arrow that was found in the defendant's trash can was found by Officer Buddy Boxer during a lawful search of the defendant's property on July 31st. This is the same arrow the defendant had access to through her classes at her junior college. She had access to the exact same arrow. Now, during a forensics test by Dr. Mildred Cheever, Dr. Mildred Cheever told us that that arrow had ferret DNA on it. Not just any ferret DNA, Your Honor, but ferret DNA with a 1 in 10,000 chance of being a ferret other than Chester. We have enough circumstantial evidence in this case to prove the defendant killed Chester. And in the eyes of the law, Your Honors, circumstantial evidence that the defendant killed Chester would be just as strong as if we presented you direct evidence.
Counsel, how
Yes, Your Honor.
confident are you in the DNA on this case when you compare the probabilities, 1 in 10,000 for
Sure.
a non-exclusion as applied to Chester versus a 1 in 7 billion probability of a non-exclusion with respect to human DNA? Why is this animal DNA, in your mind, in the state's mind, reliable at this phase of the science?
Well, Your Honor, for one case, there's not 7 million ferrets in the state of mind. There's much less. So having a ferret DNA as opposed to a human DNA, there's a much smaller number of ferrets in the state of mind than there would be human beings. So in a murder case, when there would be a 1 in 7 million chance that the defendant was the person, or not the person who committed the crime, well, in this case, there's not as many ferrets. So we have that population of ferrets, 10,000. So at this case, it's just as good of a statistic probability. The only difference is there's less ferrets than there are humans.
What about the testimony that it was possible that there was some cross-contamination? After all, there was no blood on the arrow, simply saliva.
Well, Your Honor, the saliva that was on the arrow, that's true. There was no blood on the arrow, but there was an hour between when the defendant called the animal control officer, Buddy Boxer, and when she called Officer Buddy Boxer and when she posted her tweet. So there was 1 hour between when she posted her tweet and when she called Officer Boxer. So the defendant had plenty of time to clean off any blood and throw it in the trash can. And
If she cleaned off the blood, would she not have also cleaned off any saliva?
Your Honor, I am not sure about the technicality of that, but there can be saliva in places that she could not see. But blood is very visible. It's a bright red substance, and you can see it on there. But if there's saliva on different parts of it, it may have been impossible for the defendant to see that saliva and clean it off in time. So the saliva may have stayed on the arrow without the defendant of cleaning it off because she couldn't see the saliva on there.
Aren't there many different, very reasonable explanations, though, for how that saliva got onto that arrow? Maybe Chester went into the trash, was licking the arrow. Aren't there many different reasonable explanations that you've simply not ruled out in this case?
Well, Your Honor, if Chester went into the defendant's trash can, opened the lid, found an arrow, and put his mouth on there, then I would be willing to bet that someone would have a reasonable doubt about that.
Do we have facts in the record that there was a lid on the trash can?
No, Your Honor, we do not. But there was a trash can in there, and if Chester has been gone for a couple of days and decided to jump into the trash can and put his mouth on this arrow, I don't think that's very reasonable to believe, as opposed to the defendant hiding the arrow in the trash can because she thought she would be in trouble for killing Chester in this case, Your Honor. So as we move through the reckless killing, to act recklessly, a defendant must consciously disregard a substantial and unjustifiable risk a result will occur. Now, the defendant already told you on July 29, 2015, she unlawfully discharged a weapon at an animal off her back porch. And when you discharge an arrow at an animal, there is a substantial risk that you're going to hit the animal and you're going to kill the animal. But the defendant's going to tell you that she was justified in taking that risk because she was worried about her dog and she was worried about her birds. The defendant also showed you a picture of a bird she found on her property. But the defendant couldn't tell you that either Chester or the Meadows cats killed the bird in the picture that they showed you. And the defendant couldn't tell you she ever saw Chester or the Meadows cats attack any animal on her property. Even further, Your Honors, the defendant couldn't tell you she saw Chester or the Meadows cats on her property. She couldn't tell you about one time. And we know the defendant uses binoculars off her back porch to scope out her property. And we also know...
I want to ask you a question.
Yes, Your Honor.
If the state is pointing to Ms. Landley's testimony that she never saw Chester or any of the domesticated cats that Ms. Meadows kept on her property, is that not good, clear evidence that when she shot that arrow that she wasn't taking a risk, that what she was shooting at was a domesticated animal? That the only likely subject, the only likely target under that scenario was a feral cat, which doesn't qualify as an animal under the statute?
Well, there is one thing, Your Honor, that the defendant does know, and the defendant does know that Chester wears a specific bell around his collar. And this specific bell that is worn around Chester's collar is not worn by any of the Meadows cats. So Chester's the only one who wears this bell. We know that you can hear this bell from yards away. And we know the defendant has looked in the Meadows' backyard with her binoculars. So when she was doing so, there's no doubt the defendant could have seen that bell. And even further, Your Honor, the defendant ran into Chester and Stevie on a walk, at least on one occasion. So when the defendant ran into Stevie and Chester, she must have seen that bell, and she must have heard that bell. So the night of July 29, 2015, if she was yards away, like she was saying, from her porch to where she took the shot, she must have heard that distinct bell that Chester would have had around his collar.
But doesn't that assume that the animal was Chester, which is the very thing that the state's attempting to prove?
Yes, Your Honor. It does assume that the animal is Chester, and what it is, Your Honor, that I believe that the defendant would have heard that bell if it was Chester, and if she would have shot at it, she would be being reckless, regardless of if it was Chester or an animal. But Chester had that specific bell around his collar, Your Honor.
So if the bell was loud enough for the defendant to hear, wouldn't the birds that were allegedly in the yard, wouldn't the birds also have heard the bell and been chased away? Was there, how would you account for that?
But, Your Honor, there is no facts in the record saying that what the animal was, if it was Chester, was going to attack a bird. The defendant assumed that because she saw this black shadow that she said she was assuming that it was going to attack the bird. But she never saw the animal attack the bird. So
She said she saw it pounce. Didn't she say she saw it pounce?
I do not recall that from the record, Your Honor. I recall that she said she saw a black figure. She grabbed her bow, went outside, and took a shot at an animal. And she said right after, I didn't know what I was doing. But I do not recall a pounce, Your Honor. So when the defendant took that substantial risk the night of July 29, 2015, it was an unjustifiable risk because Chester did not have rabies. Now, Ms. Fritz told you that if Chester had rabies, the defendant would have been justified in shooting and killing him. But again, Chester did not have rabies. Neither the defendant nor Ms. Fritz, two veterinarians, could tell you that Chester had rabies in this case. So when the defendant took the substantial risk that she would kill Chester, it was unjustified. And therefore, Your Honors, the defendant acted recklessly.
Is the state's position that if Chester or whatever animal had rabies, then Miss Lanley's not guilty of animal cruelty?
Yes, Your Honor. That Ms. Fritz testified that killing an animal that had rabies would be a justified form of euthanization.
So does the state need to prove beyond a reasonable doubt that whatever animal may have been injured or killed here did not have rabies?
No, Your Honor. I believe that this was just one way that the defendant was trying to say that she would have been justified in recklessly taking a shot that night. She was saying that if that animal had rabies, then I was okay in taking that shot because it's a legitimate form of euthanization to shoot a bow and arrow and kill an animal in that method.
Who needs to prove justification or lack of justification?
The burden's on the defendant for justification, Your Honor. We have to prove beyond a reasonable doubt the defendant consciously disregarded a substantial and unjustifiable risk. And from the facts in the record, the defendant was not justified in taking the shot the night of July 29, 2015, because neither the defendant nor Ms. Fritz, two veterinarians, could testify to you that Chester had rabies. And Ms. Fritz, who specializes in small animals at Lakeview Medical Center and has for 10 years, also said that there was not one case of rabies at Lakeview Medical Center during the summer of 2015. So it wasn't an issue. Rabies was not an issue at Lakeview Medical Clinic, Your Honors. Moving to the third element, the cruel manner element. In order to prove the defendant killed Chester in a cruel manner, we have to prove to you the defendant killed Chester in a manner likely to cause unjustified or unwarranted pain and suffering. Well, it's hard to argue that when you hit an animal with a bow and arrow and hit it and kill it, it's not going to die without unjustified and unwarranted pain and suffering. Sally Meadows told you about the sound she heard on July 29, 2015. She described it as a horrible sound. And she described it just like the time that Stevie had stepped on Chester's tail, but 100 times worse. But Glenda Fritz was called before you to say that the defendant would have been justified if the defendant knew that Chester had rabies. But again, Your Honors, the defendant could not tell you, and Ms. Fritz could not tell you, that Chester had rabies. So when the defendant shot at Chester, she not only killed it in an unjustified manner, but in a manner likely to cause it pain and suffering. Since we proved to you the defendant recklessly killed a domesticated animal in a cruel manner without the owner's consent, there is no reasonable doubt the defendant is guilty of animal cruelty. Now that we proved to you the defendant unlawfully used a weapon to commit animal cruelty, I want to move on to the second count, interference with a therapy animal. Now, to prove that the defendant is guilty of interference with a
Can you
therapy
address the training aspect
Absolutely, Your Honor. Chester was trained at Pause for a Cause in Lakeview Mall. At this training, Chester and the Meadows family were taught about how Chester could best be used to treat Stevie's anxiety.
Was Chester actually evaluated at that training?
No, Your Honor, he was not. He is not evaluated for his temperament, but Your Honor, under the law does not say that the animal must be tested or tested for temperament training. Thank you, Your Honors.
Thank you, counsel.
Thanks.
Thank you.
Good afternoon, Your Honors. The state has charged Caitlin Landley in connection with the death or the disappearance of her neighbor's pet, Chester the ferret. Dr. Landley is a lover of animals. Dr. Landley is a protector of animals.
Counsel, I'm going to jump right in here.
Yes.
How does the defense address the fact that ferret DNA was found on an arrow in your client's trash can?
We do not dispute the fact that the DNA found on the arrow was most certainly the DNA of Chester the ferret. It seemed to match according to the forensic veterinarian. However, there is no explanation for how saliva could have gotten on that arrow. If that arrow was indeed used to harm or kill an animal, I think it's a reasonable reference that there would have been blood on the arrow, there would have been fur on the arrow. The fact of the matter is there's no explanation for how the saliva got there on the arrow.
Isn't it possible that the ferret tried to remove the arrow after being shot with it?
That could be a possibility, I think. Certainly, if an animal were wounded, they might lick at a wound, for example, and therefore leave some sort of a trace of saliva. But again, I don't think that explains the lack of blood or the lack of fur or the fact that the arrow was intact. If you recall, Mr. Olson testified, the archery instructor testified that a wooden arrow is very fragile, that it shatters or splinters easily, and that it would be very unlikely for an arrow to have been, first of all, to even enter the body of an animal, but certainly to be removed from the body of an animal and remain intact. Of course, the other issue with the arrow is that Dr. Landley didn't put it there. There's no explanation for how that arrow got into the trash can. Certainly we know that the scene was insecure for a period of time from the time that Officer Boxer first went to the scene, and then when he went back and executed the search warrant, there was plenty of time for other things to happen to get that arrow in that trash can.
With
Counsel?
the ferret's DNA?
Well, the Meadows had DNA to be able to provide to Dr. Cheever, the forensic veterinarian, and so perhaps they had another way to put it on there. We don't know. The state has failed to prove how that DNA got on that arrow.
Counsel, your client put a tweet up shortly after this incident and then pulled it down an hour later.
Yes.
Talk me out of concluding that tampering with or removing a tweet doesn't equate to tampering with a crime scene and moving evidence, including an arrow.
Dr. Landley did not have it in her head that there was a crime scene. She was not thinking along the lines of there being some sort of an investigation. She put up that tweet because she was communicating to her friends. She had previously told her friends that there was a lady next door that had a lot of cats, that she was worried about all of these cats and the effects that they might have on her dog and on the birds in her yard. So when she put up that tweet, she put it up to communicate with her friends, not to communicate to all of social media, and certainly not to make a confession, as the state has said that tweet was a confession.
Didn't she say, my first kill?
She did. She did. However, when she said that, she had not gone to check. If you recall, her intent was to scare away what she believed to be a feral cat that was stalking a bird that was on the bird feeder.
Aren't there many other methods of scaring away an animal, such as a cat, a ferret, without resorting to such violence of discharging a bow and arrow?
There might have been, had Dr. Landley been thinking of it, but at the time, in the moment, Given the experience that she's had with the number of dead birds that have already been in her yard, she panicked. The arrow and the bow just happened to be right there because that's where she had dropped it after she had come home from class that Monday evening. And so she just, out of instinct and out of panic, she just grabbed it. Again, her intent was not to be violent. Her intent was to scare away the animal, not to harm the animal.
Let's talk a little bit about that. Even if we accept that Miss Landley's intent at the time she discharged the arrow into the yard was only to scare an animal, did she not disregard a substantial and unjustifiable risk that that arrow might kill or injure a domesticated animal?
I'm not sure that her actions even rise to the level of recklessness. If you recall, it was almost dark outside.
Well, if they do rise to the level of recklessness on that point, she's guilty, right?
Well, there might be other elements that the state hasn't proved, but certainly that would be one of the elements that they would have to prove for the animal cruelty charges, that at the very least she acted in a reckless manner. I, again, will offer that she was not acting in a reckless manner. She had no intent to hit the animal. It was dark outside, or almost dark outside, when she shot the arrow out. She was a brand new student. She had just started taking archery classes. She had no idea that there would even be a risk of her being able to hit and harm an animal.
Isn't that even more reckless, though, to discharge such a weapon in near dark conditions when she couldn't potentially see exactly where she was aiming, especially for a beginner student of archery, as you claim?
I think, again, her idea was simply to create some sort of a ruckus or some sort of an incident that would scare the animal away. So when she shot the arrow, that, again, was what she was trying to do.
Your client claims that she couldn't see that it was dark out, yet she could see the beautiful blue-gray gnatcatcher bird sitting there. She could identify the type of bird, but yet could not identify the animal she was shooting at because it was dark?
It was dusk. I'm not sure that it was completely, totally dark outside. I think we heard testimony from both Ms. Meadows and from Dr. Landley that it was around dusk time. But the fact of the matter is, Dr. Landley is a bird lover. I mean, that's her specialty, is birds. And so she can recognize birds, even if she can't get a full view of them, by their size, by their shape, that sort of thing. And so I will put forth that she could have been able to identify the bird and yet not be able to identify the dark object or the dark animal that was moving around in the grass. I would put forth that the state has not proven the elements that are necessary for unlawful use of a weapon. Although she does not deny that she discharged the bow and arrow, she does deny that she did not have the legal authority to do so. I will put forth that she had the legal authority to protect Milo.
Was it Milo inside?
We heard no testimony one way or the other as to where Milo was at the time. Certainly we can infer that he was likely inside because Dr. Landley said she had given him his nighttime medication prior to this incident happening. However, in general terms at least, we've got animals next door. We've got animals in Dr. Landley's yard that potentially carry disease, that potentially have rabies, that potentially have distemper, that would certainly negatively impact Milo, in situations where he would be exposed to those, and that was one of the reasons why Dr. Landley would have the legal authority to try to protect Milo. And keep in mind, again, the state has not proven that, beyond a reasonable doubt, that Dr. Landley did not have the authority to do so. And of course, I will also put forth that Dr. Landley had the legal authority to protect the birds. Again, as I discussed, there were bird parts in her yard, there were bird feathers in her yard, there were dead birds found in her yard, and she could not stand the idea of yet another bird dying on her property. And so she did what she did in order to protect the bird, and she had the legal authority to do so. And therefore, I will put forth that the state has not proven beyond a reasonable doubt that Dr. Landley is guilty of the use of the weapon charge, and ask you to find her not guilty. On the charge of interference with an assistance animal, we look at if the person injured an assistance animal and that the person knows or should have known that the animal was an assistance animal. The law defines assistance animal as an animal that has been trained for assistance purposes or that has been actively used for assistance purposes. The state hasn't proven that Chester has been trained as an assistance animal. There was testimony that the Meadows went to a class at the mall, that Chester went along with them to the class, and that they received a certificate after the class was over.
Well, does the statute require any special testing or evaluation? It just says training.
There is nothing in the statute that suggests what the training should be. However, I would put forth that there needs to be at least some evaluation of an animal's temperament. There needs to be some sort of recognition that the animal responds to commands, some sort of requirement other than simply attending a class.
Well, the statute doesn't require that, though. It just says that the animal needs to be trained. I mean, you know, the testimony was that this was basically a lecture of some kind talking about how animals like Chester can be used effectively as therapy animals. I mean, isn't it reasonable to infer, and indeed can't we infer beyond a reasonable doubt, that the purpose of taking Chester to this class was indeed to take those skills, put them into use, and further this animal's ability to help the boy with his anxiety?
I agree with you, Your Honor, that, again, that the Meadows did attend a training class and that they took Chester with them. I think, though, that without some sort of demonstration that the animal has learned anything in particular from attending a training like that, that really is a training for the humans, but not really a training for the animals. So if we move on with that logic, then perhaps the Meadows had 8 cats. Perhaps they could call them trained animals because, again, it was the people who were trained in that class, not the animals. The other issue...
So let me interrupt you there. I mean, I follow your logic to a point, but if the Meadows family actually went to a facility and were trained on how to train an animal, could they not then impart that training on the animal and qualify it as a therapy animal or an assistance animal? Or is it your position from the defense that the only legitimate training comes from a third party?
I guess I would put forth that even if the training itself, there might be different methods and different ways to actually provide the training, but that in the end, without something to demonstrate that the particular animal that is in question is indeed a trained assistance animal, I think that leads to a lot of doubt and a lot of speculation about whether indeed that animal is a trained assistance animal.
And how much weight should we give to the fact that the school wouldn't let this ferret into the classroom?
I think that's a very important point. In fact, the definition, again, of an assistance animal is an animal that's actively used for assistance purposes. But the school did not allow Stevie to take the animal to school. The school did not recognize Chester as an assistance animal. In addition to that, his dad didn't recognize Chester as an assistance animal. He would not let him come with him.
Wasn't it the dad's girlfriend who said that the animal could not come to the house, not the dad?
Certainly that was the testimony that we heard, that it was the girlfriend and not necessarily Stevie's dad.
It's because of her allergies.
Correct, although, again, Ms. Meadows at least put forth that ferrets and people respond differently to ferrets when they have allergies than they do, for example, from cats and dogs. However, Stevie's dad is, in fact, Stevie's dad. And if Stevie's dad were concerned about Stevie and his anxiety that we heard about and about his need for an assistance animal, then one would hope that his dad would allow Stevie to get the comfort that he felt, that they testified that he got from this animal. The only testimony that we got about the use of Chester was him going to the store occasionally with Stevie and with Miss Meadows, and Stevie walking Chester down the street on a leash. Again, I would put forth that that's not actively using Chester as an assistance animal, and that therefore the state did not meet that burden. Dr. Landley did not know that Chester was considered to be special in any way. The testimony was that it was widely known That's what the state relies on, is that it was widely known that Chester was a special animal and that Stevie needed assistance from this animal. But Dr. Landley had no way of knowing. The Chester did not wear a harness that identified him as a special animal. He did not wear anything around his collar that indicated that he was a special animal. Dr. Landley had seen Chester around, had seen him with Stevie around, but that does not tell her anything about the status of the animal. In addition to that, the state makes a big deal out of the fact that Chester was a patient at the same veterinary clinic where Dr. Landley works. Dr. Landley has no way of knowing all of the animals that are patients in that facility.
So I'm going to interrupt you for just a moment. Does the state need to prove that Dr. Landley actually knew?
The state needs to prove that she either knew or should have known.
So given reasonably known, correct? So given all of the facts that you've just laid out, the harness, the vet clinic that both Chester and Dr. Landley, of course, frequented, shouldn't Dr. Landley have reasonably known that Chester, a ferret who was walked on a leash, who wore a bell, who lived next door, was a special therapy animal to Stevie?
Again, I will put forth that just because something is widely known doesn't mean that individuals know things. The fact of the matter,
reasonably should know.
Again, I'm not sure that lack of a harness, that lack of anything to identify Chester as an assistance animal, the fact that Dr. Landley had no reason to be in the part of the clinic where Chester would have been treated if he were ever to go there to that clinic. There's no way that she should have even known all of the animals that were there. Simply seeing an animal being walked down the street on a leash does not indicate that that animal is special in any way. And so I will put forth that there was no way that she even could have known.
But it was a ferret with a harness.
Unusual.
And even your client acknowledged that that was super weird.
Yes, yes. But if she didn't pursue anything further other than going, hey, look at that ferret on the harness, if she never pursued any additional, seeking out any additional information. And you heard testimony from Ms. Meadows that their relationship was not exactly a stellar neighborly relationship. Ms. Meadows believed that Dr. Landley was unfriendly. There was never much communication there, so there wasn't even any sort of direct communication.
But they could see each other from the backyards, and they were often in each other's view in the backyard. The defendant knew that Stevie was in the backyard many times with Chester, his ferret, and could see it, and in fact had binoculars peering through into Stevie and Ms. Meadows' backyard.
I'm not sure, first of all, Your Honor, that Dr. Landley used the binoculars to peer into the neighbor's backyard. The binoculars were to try to...
But there was no privacy. There was testimony that there was no
Correct.
privacy between the two yards, so they were clearly visible to one another.
That's correct. In addition, again, to the cats that would have been in the backyard, those were also visible to Dr. Landley. If we would want to infer that her seeing Chester in the backyard with Stevie makes her know that Chester was considered to be a special animal, then we could also argue that seeing him with the cats in the backyard would also make them special animals. And of course, that's not what the state has offered today. Lastly, we don't even know if Chester was the injured animal. Chester disappeared. We know that much. We know that Chester has not returned home. We know that there may have been an injured animal. However, there was no animal that was ever found.
Does the state need to prove that it was Chester?
Yes, I believe so, because again, when we talk about the animal, the definition of animal under the statute, we're talking about a domesticated pet.
Couldn't that have been one of the cats, one of the 6 domesticated cats, or just any domesticated cat in the neighborhood?
It could have been any domesticated animal. However, again, Dr. Landley believes she was shooting at to scare off a feral cat, and feral cats are not domesticated animals, and they are specifically excluded from the statute. So again, we're talking about an undomesticated creature as the animal that was in question. I would put forth, Your Honors, that the state has failed to prove beyond a reasonable doubt all of the elements of all of the charges for which she has been charged. We have an animal that does not fall under the definition of an animal. We have the question about where Chester is. We don't know where he is. The state has not been able to show that he was even the animal that was injured. We have the arrow that lacks the blood or the fur or anything to indicate that there was violence perpetrated on any animal, let alone on Chester. We have the fact that Dr. Landley had the legal authority to protect Milo and to protect the birds. We have the fact that Dr. Landley did not know that Chester was considered to be a special animal. And we have the fact that Chester was not trained and actively used as an assistance animal. And for this reasons, I will put forth that the state has failed to meet its burden of proof beyond a reasonable doubt of the elements of these charges, and therefore I pray that you find her not guilty of all counts.
Thank you.
Thank you.
Yeah.